Report of the Center State Relations Inquiry Committee, Government of Tamil Nadu, 1971, read by Ramani. Chapter 9, Emergency Provisions. Three types of emergency are contemplated by the Constitution and are dealt with in Part 18. They are: 1. Emergency confined to a single state, that is, failure of the constitutional machinery in a state. 2. Emergency of a national scale, that is, arising out of war, external aggression, or internal disturbance. And 3. Special emergency involving a threat to the financial stability or credit of India or any part thereof. 1. Emergency confined to a single state. We may first deal with the emergency arising out of failure of the constitutional machinery in a state. Articles 356 and 357 relate to the topic. From a perusal of the proceedings of the Constituent Assembly, it will be observed that Articles 356 and 357 were adopted in the face of opposition by several leading members of the Constituent Assembly. There is no provision similar to these articles in any other federal constitution. This is a provision inherited from the 1935 Act. The condition precedent for the operation of Article 356 is the satisfaction, be it noted subjective, of the President, that is, the Union Ministry, that, quote, a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of this Constitution, unquote, quote again, on receipt of a report from the governor or otherwise, unquote. The Constitution does not define as to what constitutes a situation of the type just now mentioned. No clear rules or conditions have been laid down to decide what constitutes failure of a state's machinery. An interesting article has been contributed by Thiru Shivraj Nakade on Article 356 and how it has been used so far. From the manner in which the article has so far been used, the writer has deduced the following three general features. 1. The central government, which had a Congress majority at the center, as well as in most of the states, acted in accordance with political expediency in imposing president's rule. 2. It exercised extraordinary powers in keeping state administration under its direct control in the absence of an alternative ministry in the state. 3. On a good number of occasions, the central government had given the impression that Article 356 was used to restore democracy in states. The author has dealt with each one of these occasions in which the article was put into operation, beginning with East Punjab, which was the first state to come under President's rule in June 1951. In all, he has given 19 instances where the article was put into operation in different states. We may here point out that he has also referred to instances relating to the Union territories of Goa, Manipur, and Pondicherry, but Article 356 does not apply to Union territories. It deals only with states. The provision applicable to Union territories is Section 51 of the Government of Union Territories Act 1963, Central Act 20 of 1963, which deals with a situation in the Government of Union Territories similar to that contemplated by Article 356 in relation to states. According to the author of the article, the provision was used in East Punjab in 1951 as, quote, a device to end party rivalry and maladministration of the state, unquote. The central government's action in bringing PEPSU under President's rule in 1953 may, according to the author, quote, appear to be a partisan, unquote, action, quote, to serve party interests, unquote. Dealing with President's rule in Orissa in 1961, he says that it has become a general practice of the Congress Party that whenever they were sure to capture power in the midterm elections, they managed to impose President's rule and favored the dissolution of the state legislature. Dealing with another instance, he has recorded it as his opinion that the ruling party's interests were served in not allowing formation of a non-Congress government, and that, therefore, the people rightly felt that within the democratic setup they were punished for not electing members of any political party with a clear majority. It's not for the committee to discuss and consider the question whether the central government was justified on those occasions in assuming powers of the government of the state under Article 356. The committee is referring to the instances only to show that the power is capable of being used to deprive the states of their autonomy. The author has suggested four remedies to cure the defects inherent in Article 356. They are 1. An amendment of the Constitution laying down conditions under which the power could be exercised, 2. Making the power justiciable by the Supreme Court, or in the alternative, casting an obligation on the President to obtain the advisory opinion of the Supreme Court before bringing a state under his direct control, 3. Making the office of the governor elective, and 4. Constitution of an advisory body consisting of High Court and Supreme Court judges and taking its opinion. The opinion of the advisory body should be placed before Parliament when it is in session and before the parliamentary board constituted for the purpose when Parliament is not in session. The President will act only with the approval of the Parliament or of the board. Thiru K. Santhanam, in his article entitled Propriety of Midterm Dissolutions and published in The Hindu, dated the 2nd of July 1970, has, while commenting on the scope of Article 356, this to say, quote, the imposition of presidential rule whenever a ministry is defeated and no alternative ministry can be found is one of the most unsatisfactory aspects of the Indian Constitution. Ordinarily, when a ministry is defeated and an alternative ministry cannot be found, the proper course should be immediate dissolution and re election so that people of the state will have a chance to decide for themselves. It's only where law and order cannot be maintained and the legislature cannot function in peace that presidential rule can be really justified. In the discussions in the Constituent Assembly on Article 356, it was emphasized by many speakers that except in cases of civil disorder, presidential rule should not be imposed without first a dissolution and general elections. Unquote. Basu, in his commentary on Article 356, has stated that as to the circumstances when the power under Article 356 may be exercised, no precise definition is possible for the simple reason that the question is non justiciable. According to him, the entire decision is left to the governor and the union executive, and there is no sanction prescribed against any possible abuse of this power. He envisages only two contingencies as justifying the promulgation of a proclamation under the article. They are 1. A political breakdown, that is, when a ministry has resigned and an alternative ministry could not be found, without a fresh general election in the state, and where the party commanding a majority refuses to form a ministry and a coalition able to command a majority in the legislature cannot be formed. And two, that the very words court in which the government of the state cannot be carried on in accordance with the provisions of this constitution and court indicate that the article is not intended to supersede the other provisions of the constitution relating to states. Example, the provisions of Article 163 and 164, and that accordingly it would not be proper to unseat a ministry so long as it commands a majority in the state legislature. He is of the opinion that it's difficult to justify the proposition that although a ministry commands a majority in the state legislature, it may be dismissed on the ground that it has lost the support of the majority of the people at large because, according to him, there is no provision in the Constitution requiring that the ministry must, in addition to the support it has in the legislature, command the confidence of the people outside the legislature. It's an admitted fact that there have been complaints that Article 356 has been used for a purpose which was not in the minds of the framers of the Constitution. The position of the governors has been rendered more difficult by the use of the article. Accusations have been leveled that the governor was merely acting as an agent of the central cabinet whenever Article 356 was invoked. The latest case which has subjected the governor to strenuous criticism is that of Uttar Pradesh. President's rule was promulgated in that state, and a few days immediately thereafter, the proclamation was revoked and a popular ministry assumed office. Article 356 is an unusual provision not found in other federations, and the Union, after all, is one of the parties to the Federal Compact, and the vesting of such unguided discretion in the Union is bound to work to the detriment of the states. It's a political party or a combination of political parties which runs the government, whether it is at the center or in a state, as pointed out by Professor N.G. Ranga in a speech at the Indian Parliamentary Association Symposium held in New Delhi on the 3rd of May 1970. There must be some safeguard against the center's misuse of power. In the course of his speech, he said that while the states go wrong, it's possible for the center also to behave in a very unreasonable manner. We may refer here to the following comments of Thiru Ashok Chanda on these articles in his Federalism in India. Quote, these are extraordinary provisions absent in all other constitutions. The invasion of the legislative and executive jurisdiction of the states is also repugnant to the very concept of its federal constitution. Though imbibing the principles of democratic constitutions, the Indian constitution is not altogether free from authoritarian trends which it inherited in accepting the basis of the 1935 Act, unquote, page 67. Quote, the provisions for the suppression of state government and its legislature and the suspension of the constitution in the state are not only unusual but extraordinary, not present in any other constitution. The article has been invoked for this reason more than once and in more than one state. Its provisions may also be invoked, as mentioned earlier, if a state fails to carry out central directions on matters specified. In the event of gross misgovernment in a state also, there is no constitutional bar to central intervention. The use of the word otherwise makes this intervention possible even without formal report from the governor. The Constitution does not provide for the suspension of the constitutional machinery of the Union, but only of the states, and that also by the issue of a proclamation by the President. The decision of the suppression of a state government has thus to be taken at the instance of the Union Executive. Secondly, the powers come to be vested not in the governor but in the president, though he may use the governor as his agent for such purposes as he specifies. The Constitution thus gives the Union Executive in the first instance and Parliament later the right to bring a state completely under central administration. Though there has been no abuse of this power so far, there is nothing to prevent an abuse in future. Furthermore, it's the Union which determines whether there has been any lapse on the part of a state in carrying out central directions or whether there has been a breakdown of the constitutional machinery in a state. No legal remedy has been provided to the state to contest the validity or justification of suppression. Pages 100 and 101, unquote. Again, Dr. K. Subbarao, in his Lal Bahadur Shastri Memorial Lectures delivered in March 1969, has this to say regarding Articles 356 and 357. Quote, this provision is intended to preserve and protect democracy, but it is capable of great abuse. Since the present Constitution of India came into operation, there had been many occasions when this power was invoked. 1951 in Punjab, 1952 in Pepsu, 1954 in Andhra, 1960 in Kerala, 1961 in Orissa, and 1967 in Rajasthan and Haryana, 1968 in West Bengal, Punjab, and Bihar. There was a strong public criticism that in most of these said cases, it was not possible to say that the state could not be carried on in accordance with the provisions of the Constitution within the meaning of Article 356 thereof. These proclamations and the criticisms bring out the inherent conflict between the center and the states, which, unless reasonably solved, will put the said relationship in peril. The solution for this conflict lies in the true interpretation of Article 356 of the Constitution on the building up of healthy conventions. Unless the party that happens to be in power in the center develops conventions to shed its party affiliations in the matter of its relations with the states, the federal government cannot effectively function in our country. Unquote. Articles 356 and 357 may therefore be entirely repealed. The only other alternative is to provide safeguards to secure the interests of the states against the arbitrary and unilateral action of a party commanding overwhelming majority which happens to be in power at the center. But as pointed out by Thiru K. Santhanam and Pandit Kunzru, the only contingency in which President's rule may justifiably be imposed is the complete breakdown of law and order when the state government is unable or unwilling to maintain the safety and security of the people and property. In the interests of the stability and for assuring the states that they will be free to function without fear of Article 356, it seems desirable to incorporate the necessary provision in the Constitution itself. It will be observed that the Union Executive could invoke Article 356 even without a report from the Governor, quote, the man on the spot, unquote. Thus, President's rule could be promulgated on the basis of extraneous sources. In fact, Thiru H.V. Kamath protested in the Constituent Assembly against the use of the words caught or otherwise uncaught occurring in the article. Professor Shibanlal Saxena supported Thiru Kamath. The latter stated that the word otherwise is mischievous and diabolical. In dealing with the appointment and functions of the governor and his relations with the state cabinet, we have emphasized the fact that the governor should not deem himself to be a mere agent of the center and that the emphasis should be on his role as the constitutional head of the state. We have also suggested issue of instruments of instructions to the governors regarding the exercise of their functions, including the exercise of discretion. We have also recommended that the tenure of office of a ministry in any state should not be dependent on the pleasure of the governor and that the ministry should continue to function and perform its allotted duties so long it's able to command a majority in the Legislative Assembly. Consistent with these recommendations, this committee is of the view that the President should not have the power to bring under the control of the Union the administrative and legislative machinery of a state, except on receipt of a report from the governor. The governor is the highest dignitary in the state, appointed by the Union. It's difficult to envisage a situation where the President can come to any decision under Article 356 regarding the feasibility or otherwise of the government in a state being carried on in accordance with the Constitution, except with reference to a report from the governor. We accordingly recommend that if Article 356 is to be retained, the words or otherwise occurring in Clause 1 of the article may be omitted. It follows from the above recommendation that the governor, before recommending President's rule, should explore all possible avenues open to him to secure a ministry which would command the confidence of the legislature. It's only as a last resort that the governor should normally send a report under that article. The only other contingency which would justify the imposition of President's rule is the one we have already mentioned above, namely the complete breakdown of law and order in the state. The only forum which could decide the question whether a ministry could continue in office is the Legislative Assembly. Even if the governor is personally of the view that the situation warrants the promulgation of President's rule on any particular occasion, we would suggest that the President should, before actually issuing the proclamation, afford a reasonable opportunity to the state legislative assembly for expressing its views on the report of the governor. The immediate result of the imposition of President's rule in a state is the virtual dismissal of the ministry, but the more important aspect to be considered is that the state legislature assembly may either be dissolved forthwith or be kept in suspended animation. In either case, the assembly is rendered ineffective and cannot function. Hence, it is that we suggest that on the analogy of principles of natural justice, the party likely to be affected by the imposition of President's rule, namely the state legislative assembly, should be given an opportunity to consider the issue and give its opinion before that august body is immobilized. We therefore recommend the addition of a proviso in Clause 1 of Article 356 requiring the President, before issuing the proclamation, to refer the report of the governor to the Legislative Assembly for expressing its views thereon within such period as may be specified in the reference. The imposition of the President's rule is dependent on the subjective satisfaction of the central cabinet, and any reason may be good enough for the purpose. The Constitution itself specifies one such ground in Article 365. The phraseology employed in that article is identical with that of Article 356. Both the articles use the words caught a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of the Constitution, unquote. Article 365 operates, quote, where any state has failed to comply with or to give effect to any direction given, unquote, by the Union, and it automatically attracts Article 356. Who is to decide whether or not a state has complied with or given effect to those directions? It's again the Union Cabinet, and here too it's arguable whether the issue can be agitated in a court of law. In the chapter relating to administrative relations, we have touched upon the scope of Article 365. We have also drawn attention to the opposition in the Constituent Assembly to the enactment of this article. We have pointed out that it was fiercely attacked by several leading members of the Assembly. Among them was Pandit Kunzru. They were dismayed at the drastic power of the article. It was characterized by some as a reproduction of the hated Section 93 of the 1935 Constitution, quote, in all its nakedness and horror, unquote. Another point which has to be repeated here is that this provision was introduced in the Assembly just 11 days before the Constitution was finally adopted by the Assembly. We have already indicated that it is this provision which renders most obnoxious the other provisions of the Constitution authorizing the Union to issue directions to the states. This provision has no precedent in any other federal constitution. We have also indicated in the chapter on administrative relations that any contravention of or failure to implement a direction issued by the Union to the state should, under no circumstances, be made a ground for the imposition of President's rule. It follows that Article 365 has to be repealed. 2. National emergency. On the issue of a proclamation by the President, court, that a grave emergency exists whereby the security of India or any part thereof is threatened, whether by external aggression or internal disturbance, the allocation of both executive and legislative functions between the Union and the states, as well as the division of financial resources between the two layers of government, become modified to such an extent that the Constitution almost gets itself converted into a unitary type. Article 352 is modified on Section 102 of the 1935 Act, but there are two differences between the two provisions. One is Section 102 of the 1935 Act referred to the threat to the whole country, whereas Article 352 refers also to the threat to any part of the country. Another difference is that the section referred only to war or internal disturbance, but the article refers to external aggression also. We are drawing attention to these differences, not with a view to suggesting any modification to Article 352. We are only trying to say that Article 352 is much wider in scope than its counterpart in the 1935 Act. Insofar as the states are concerned, the consequences of the issue of a proclamation of emergency under Article 352 are threefold: executive, legislative, and financial. On the legislative plane, once a proclamation of emergency is issued, Parliament is clothed with the power to make laws for any state, even with respect to any of the matters enumerated in the state list. Article 251. Again, Parliament is enabled by Article 353b to make laws conferring powers and imposing duties upon authorities and officers of the central government, although such powers and duties may relate to a matter within the competence of the state. Coming to the executive side, the executive power of the Union extends to the giving of directions to any state as to the manner in which the executive power thereof is to be exercised. Article 353A. This will be in addition to the power conferred on the Centre by Articles 256 and 257. The directions under Article 353A may relate to a matter included in the state list. Those directions could be enforced by the Centre by invoking Article 365, read with Article 356. As regards the allocation of revenues between the Centre and the units, the Union, that is, the Cabinet at the Centre, is invested with absolute powers to modify the entire scheme of division of financial resources as between the Union and the States during a period of emergency. The detailed scheme of distribution of revenues between the two layers of government, embodied in Articles 268 to 279, can, if the Union Cabinet so chooses, be set at naught under the pretext of national emergency. Dr. K. Subba Rao, in his lectures mentioned earlier, says, quote, under Article 352 of the Constitution, if the President is satisfied that a grave emergency exists whereby the security of India or any part of the territory is threatened, whether by war or external aggression or internal disturbances, he may, by proclamation, make a declaration to that effect. The effect of the issuance of the proclamation is 1. Parliament will have power to make laws for the whole or any part of the territory of India with respect to any of the matters enumerated in the state list. 2. The executive power of the Union extends to the giving of directions to any state as to the manner in which the executive power thereof is to be exercised. 3. The Parliament will have the power to make laws conferring powers and imposing duties on Union or other officers in respect of matters not enumerated in the Union list and in respect of matters even in state list. 4. The President may even modify the application of provisions relating to the distribution of revenues. This extraordinary power is capable of abuse. If one party captures power in the center and different parties capture in all the other or some of the states, there may be temptation on the part of the farmer to resort to the easy method and draw the entire power to itself. The circumstances under which the state of emergency had been continued by the party in power and now in the center for 5 years certainly creates a reasonable apprehension that the said power may be abused in the future. Unquote. As already indicated, we do not propose to suggest any modification to Article 352 or any of the provisions setting out the consequences of the issue of the proclamation of emergency under that article, but we suggest that a convention should be established that unless the proclamation has been issued on the ground of actual war or a threat by some foreign power to our borders, the drastic powers conferred on the Union, such as making of laws in relation to state subjects, modifying the financial arrangements, etc., should not be exercised. Another suggestion which may be considered is that the making of proclamation of emergency on the ground of internal disturbance confined to any particular part of the country should, as far as possible, be avoided. It may be interesting to note that the Joint Committee of the British Parliament, which considered the proposals, which were ultimately embodied in the Government of India Act 1935, devoted a paragraph to the need for Section 102 of that Act. In that context, the Joint Parliamentary Committee suggested that the expression, quote, internal disturbance, unquote, Court again should be defined in terms which will ensure that for this purpose it must be comparable in gravity to the repelling of external aggression, unquote. In the contingency referred to by the Joint Parliamentary Committee, where the internal disturbance is confined to any particular part of the country, the more appropriate article to be invoked will be Article 356, subject to our earlier remarks regarding this article. We have already referred to the power that accrues to the center under Articles 353A to issue during the operation of a proclamation of emergency directions to a state as to the manner in which the executive power of the state is to be exercised. While dealing with the administrative relations, we have dealt with the power of the Union to issue directions and the other provisions of the Constitution, such as Article 256, 257, 344, 6, etc. Article 353A cannot obviously be omitted. We recommend that no direction under Article 353A should be issued except after consulting and with the approval of the Interstate Council. If, however, during a period of emergency, consultation with the Interstate Council is likely to delay the issue of directions under Article 353A, to meet any emergent situation which calls for immediate action, the direction may be issued without placing the matter before the Interstate Council, subject to the condition that the Interstate Council should, at the earliest possible opportunity, be appraised of the directions so issued and subsequent action taken in relation to the matter in conformity with the recommendation of the Council. As in the case of the other articles empowering the Union to issue directions to the states, here also any omission to carry out the directions under Article 353A should, under no circumstances, be a ground by itself for the imposition of President's rule. 3. Special emergency involving threat to financial security. The provisions in the Constitution relating to the breakdown of the governmental machinery in a state and to the issue of the proclamation of emergency are based on precedents in the 1935 Act, but the provision relating to an emergency arising out of a threat to financial stability and credit had no precedent even in the 1935 Act. It goes without saying that, like the other two articles, namely Article 356 and 352, the provision relating to financial emergency also has no counterpart in other federal constitutions. Article 360 refers to the issue of directions by the Union, which means the central cabinet requiring the states to observe, quote, such canons of financial propriety as may be specified in the directions, unquote. The Constitution does not say what those canons of financial propriety are. Under the article as it now stands, those canons are unnamed and unspecified. The article goes further and empowers the Union to give such other directions as the President may deem necessary and adequate for the purpose. The expression any such direction may include in subclass A of class 4 of the article is so comprehensive that besides the two matters mentioned in that subclass, the direction may include any and every provision which the Union Cabinet Court may deem necessary and adequate for the purpose, unquote. In other words, one political party in power at the center has the absolute discretion, uncontrolled by any constitutional provision, to issue any direction it pleases to another political party in power in a state. We have already indicated that failure on the part of any state to carry out the directions issued by the Union will ultimately result in the abrogation of the constitutional machinery for the administration of the state, and the state being taken over under the complete and absolute control of the Union Cabinet. The article, it'll be noticed, does not deal with a situation where the threat to the financial stability or credit is traceable to the acts of commission or omission of the Union. Thiru K. Santhanam, in his book Union State Relations in India, commenting on the article, says, quote, well, it may happen that the financial instability may be the result of the actions of the Union government, but still the states may have to pay the penalty. Unquote, page 12. It does not appear that Article 360 has ever been invoked so far. Presumably, no situation of the nature contemplated by the article has ever arisen, or any such situation having arisen, it was considered inexpedient or undesirable to invoke the article. In either case, the article seems unnecessary. No useful purpose is likely to be served by having a provision in the Constitution which only acts as a sort of irritant in the relations of the states with the center. There is no need for a provision constituting the center as a sort of superior tribunal to watch over the finances of the states, especially in the absence of an independent authority to perform a similar function in relation to the finances of the Union. We recommend that Article 360 may be repealed.